Good morning. Welcome to today's session of the 5th District Court of Appeal. As you heard, I'm Meredith Sasso from Orange County. Sitting to my right and your left is Judge Richard Orfinger from Volusia County. And to my left and your right is Judge Anthony Taddy, who's visiting us from Marion County. I would ask that everybody please silence your cell phones before we get started. We have 3 cases set for today. We will take a break between the second and third case for coffee in the lounge, and we would invite any of the attorneys that are here today to join us. I will automatically reserve 5 minutes for rebuttal unless you ask otherwise. And with that, let's get started.
Good morning. May it please the court. I'm Robert Morris. I represent the appellant in this matter. And I would like to reserve the 5 minutes as well. This is a case regarding the rebuttable presumption of negligence. This issue has been before this court on numerous occasions. There's a storied history of it. We brought this matter because there are several issues that sort of present an interesting twist on it. And may further jurisprudence on the issue down the line. Specifically, what happens when, on its surface, it appears as though there are 2 very distinct versions of an auto accident. But when you boil it down, you see that under either theory, the rear-ending driver did not import any negligence onto the lead driver, Mr. LYNN FONGER. And he also did not rebut the presumption of negligence against himself. The most recent case that this court analyzed the issue on would be Restall v. Nocera. I think that case really goes to show sort of why this matter must be reversed, specifically our directed verdict motion on the rebuttable presumption and the negligence of as a matter of law as to Mr. NALL. In Restall, this court found that there's a distinction between a rear-ending driver being negligent as a matter of law and whether there's comparative fault on the non-rear-ending driver, the injured lead driver. In that case, this court found that to be negligent as a matter of law, there's sort of a 2-pronged inquiry. I'm sure there's other manners of determining that, but in Restall, the matter was, one, it was really undisputed that a rear-end accident had occurred, and 2, that the rear-ending driver was following too closely. It's very similar to what we have here. There's no dispute that NALL rear-ended FONGER, and while NALL did not, he couldn't recall whether he was following too closely. He couldn't recall the distance. He did say that he wouldn't have been able to avoid the accident regardless based on his distance to FONGER. That would be at record 2357. I think it's a critical page for the court to review if it's interested. Additionally, he also said he only applied his brakes when he heard FONGER apply his brakes, and despite having seen the alleged phantom vehicle in the roadway sitting at a green light.
And that's all reasonable inferences to draw from the evidence, but as you know, we're trying to see, when we look at the standard of review, it's whether there's any view of the evidence that could support the verdict. And as you've mentioned, there are several cases on it, but all the cases are, I think you would agree, incredibly fact-specific. Yes.
To an extent, yes.
So, looking at the inferences that can be drawn from this evidence, why isn't, for instance, how it was summarized that he was traveling too close to the phantom vehicle, that paused or stopped when approaching a green light, or that came to a sudden unexpected stop in an area that could not be expected, right before a green light? Why isn't that an inference that the jury could reasonably draw from this evidence?
Right. The inferences must always flow logically from the evidence that's presented. I believe the court's referring to page 13 or thereabouts of the answer brief, where some of these inferences were really concocted by the appellee. They don't necessarily follow from what was adduced at trial. For instance, I believe the first mentioned was that FONGER wasn't warranted at braking at a green light. But the testimony of NALL, the rear-ending driver, was that the only reason that FONGER stopped was because there was a phantom vehicle sitting at a green light as they were both
Well,
traveling
it's
down the
not
track.
materially different from how it was summarized in closing argument either, though. And that's what the jury heard. There was no objection to the summary and closing argument, that it was facts outside the evidence or anything like that. So why was that summary during closing argument not a reasonable inference that the jury could draw?
I can't recall if there was an objection to that specific summary or not, to be perfectly honest, but
Let's assume
yes,
there wasn't.
In closing, certainly counsel can try and interpret or guide an inference for the jury, but always the jury must follow the inference. Well, their inferences can only flow from the evidence adduced. They're not allowed to deviate from that. They're not allowed to.
Well, there was evidence adduced that the jury could infer that there was a sudden stop in front of a green light. Yes?
Correct, but the various courts, this court, and in fact the Supreme Court, I think it's Burge v. Sharon, says that it's not an illegal or improper stop to avoid an accident. In fact, every driver has an affirmative duty to do that. It wouldn't be reasonable to say that FONGER should plow into the driver in front of him simply to enjoy a presumption of negligence down the line in a possible suit. So,
And why wouldn't it be a reasonable inference that there was a sudden stop in front of a green light that was not caused by a phantom vehicle?
yeah, I think this largely goes to the reason why we needed the directed verdict on negligence granted, because this is a legal question for the judge to decide. It wasn't really a question for the jury. So any discussion about this in closing, about whether FONGER was negligent, whether NALL had any negligence, it shouldn't have gone to the jury. It should have been brought up in closing. It should have been decided by the court, and the only issue for the jury would have been possibly comparative fault, which,
Isn't that inconsistent, though, with the idea that, especially in negligence cases, these are highly fact-intensive questions that should almost, except for in rare circumstances, go to the jury?
Well, that's why we have presumptions, though. This is a presumption that I believe FONGER enjoyed, and it was NALL's burden to rebut that. He didn't do so in this particular case. The facts presented are simply that. So if that's what happened, then that particular question doesn't go to the jury. They're not allowed to decide that. And that's what we're asking the court to determine here and eventually reverse the lower court's order on the directed verdict and order a new trial. Because while, again, I disagree with any comparative on FONGER's part, but if there was some, fine, we can have a new trial on the comparative. I think the new trial should only be for damages, but what it boils down to is that the negligence question and what happened was not something the jury should have been able to decide. It's confusing, it's misleading, and you get a result like we have here, where the jury found that the rear-ending driver, NALL, was 0% liable for this accident, 0% at fault, no fault. This flies in the face of every case this court has heard on the matter, and really the courts around the state as well. Tacker v. Asmus and then Burge v. Sharon. This is a case where if you look at the facts, under either theory of the case, or the accident, excuse me, you have a lead driver who really did nothing wrong. He couldn't have done anything different. Under his own story, he stopped at a red light within a reasonable time frame, and he was able to do so without blowing into the intersection or crossing the line. Under the rear-ending driver's theory,
Would it be wrong for a lead driver to come to a sudden stop within 10 feet of a stop bar in front of a green light?
I think as long as the stop was reasonable and safe, according to FONGER's testimony, he didn't slam on the brakes. The slamming on the brakes only comes from NALL's
But
testimony.
again, right, and that comes from NALL's testimony. So when you're sitting in the seat of a juror, they've heard testimony that the lead driver slammed on their brakes within 10 feet of a stop bar in front of a green light, which couldn't a juror determine that that was improper or wrong?
It may go to the comparative aspect. It doesn't go to the fact that NALL was negligent as a matter of law, and that's something the jury should have heard. They may have, really what I think should have happened would be that they were told, you are to assume that NALL is negligent as a matter of law. You are to decide what percentage of fault, if any, is on the part of FONGER. But they weren't given that option. They were simply asked, was there any negligence on the part of James NALL? That's the question they stopped at, and they had to stop because of the way that the defendants, or excuse me, the appellees' verdict form read. They weren't allowed to go any further and give us any more insight on that. So that's sort of the crux of our issue here with this case, is that the jury was allowed to hear these things and to assume that FONGER was somehow 100% at fault for, even if they did assume that he stopped too quickly coming toward a red light, that's not 100% fault. Legally, under all the case law, all the jurisprudence, that would not put all of the fault on that lead driver who simply stopped at a red light, which he had a duty to do. So I think that really goes to the heart of why the jury was confused, why we believe the jury was confused in this. A brief point I'd like to touch on was the ruling of the trial court itself on the directed verdict motion. That can be located in the hearing transcript at 2528 and 2538. We don't have a formal order with any explanation on it. All we have is the words of the judge at the hearing. And basically the problem with that is that the court, despite being given all of the case law that has been briefed, with the exception of Ristall, which hadn't been out yet, obviously, the court analyzed this issue incorrectly. The court took the sort of surface matter disputes, such as whether or not there was a phantom vehicle, whether the color of the light was red or green, and then a discussion about whether there was an available route around FONGER. None of these issues are what should have been analyzed when determining whether a directed verdict was appropriate. The appropriate analysis would have been, one, did NALL present evidence that would show he was not negligent? And two, if so, or in any case, in either event, was there evidence to support FONGER was comparatively negligent? Those are the only two issues that matter. And while there is some overlap between those two things, really what you have is an improper analysis. Whether there was a phantom vehicle or not doesn't matter. That actually is discussed in a case from this court of Baumann v. Vaughn. It was briefed. I don't have a cite on it, but in that case, this court said that when the only issue and the only way that the rear-ending driver could rebut the presumption was to claim some information about a phantom vehicle, that a directed verdict on negligence was appropriate, and this court sent the case back for a trial on damages only. It's sort of what we're asking for here. The only real evidence that NALL's provided, and again, I think we have to look at NALL's testimony because that's his testimony. One would assume that that's the most favorable testimony to him. So looking at his only, FONGER stopping at a vehicle, a phantom vehicle sitting in the roadway, what did FONGER do incorrectly? He had a duty to stop, and also NALL had a duty to maintain appropriate distance and not hit drivers sitting in the roadway, or drivers in front of them, rather. Everybody has that duty. It's also established that when anybody is approaching a busy intersection, they have a duty to expect to stop. This court said that in Douglas Siebert. I think the third DCA in Tacker said something similar.
And in those cases, was the light green at the intersection?
Douglas Siebert was a little bit different because there was a car that pulled out in front of a chain of cars, and it caused the lead SUV to slam on its brakes, and then Douglas Siebert was behind that, and she slammed on her brakes, and then a third vehicle ended up hitting her.
And then they had all stopped, and then the front car started moving, and the second car, for whatever reason, did not stop moving. So that's a little different here because they had all been stopped, and then they started moving, whereas here there's a sudden stop at a green light. So again, it goes to the kind of the fact-intensive analysis of these cases, right?
There's always a fact-intensive element to it, but the gist is the same in all of these. There's four readily defined categories of when the presumption is rebutted. One of those is a sudden stop, which is frequently claimed, and that's also been heavily discussed. And again, it is not a sudden or unexpected stop when a person is trying to avoid getting into an auto accident themselves.
And I guess my questions are going to, obviously it was a sudden stop, but why doesn't this fall into the category of cases, or why couldn't the jury not reasonably infer from the evidence this falls into the category of cases where it could not be reasonably expected that the driver would stop at the time and place where they did?
Which driver, Your Honor? FONGER or NALL? I'm sorry.
FONGER.
Well, I mean, just legally speaking, that's why we think it should have been addressed in a directed verdict. He was absolutely within his rights, and in fact, he had to make that stop. He had to avoid hitting the car in front of him.
Because he had to stop there, assuming that's true, does that automatically impute negligence on the driver behind him?
I certainly think so.
Even if it's unexpected, because we're looking at what's reasonable.
Right, and NALL himself said at record 2361, FONGER was forced to stop because of that car in the roadway.
Doesn't that kind of eviscerate the purpose of the presumption, though, and it would make just a kind of de facto per se liability in every rear-end case?
No, I don't think so, because I mean, as the court mentioned, these are all fact-specific. This is a case where the vehicle was sitting in the roadway and the driver behind him had no choice but to stop. And so FONGER did stop. He didn't impact the supposed phantom vehicle. And if I could just reserve the remaining portion of my time, I'd appreciate it. Thank you.
May it please the Court, Angela Flowers on behalf of James NALL. Contrary to plaintiff's argument, the trial court did not err in either denying the plaintiff's motion for directed verdict or denying the motion for new trial. In regard to the directed verdict issue, it's important to note that plaintiff only moved for directed verdict on the ground that defendant was solely responsible for the automobile accident. This is different from many other cases, which, as the court recognizes, are all fact-specific, but specifically it's different from Restall because in Restall, this court was faced with the entry of a partial summary judgment against the defendant based on there being some uncontradicted evidence that the defendant was at least partially at fault. This case is entirely different in that the parties acknowledge that the facts were highly disputed in regard to how the accident occurred.
But if we take the facts in a light most favorable to your client's story, as I understand it, is they're going through the intersection, they have a green light, this phantom vehicle slams on its brakes unexpectedly, which causes Mr. FONGER to slam on his brakes, and then Mr. NALL hits FONGER from the rear. Why doesn't the Epler versus Tarmac case say you've got to anticipate stops even in intersections, control? So we take those facts most favorable to your client. Why doesn't your client still lose, at least as far as not overcoming the presumption?
Well, the current state of the law no longer articulates this concept that you are to expect a sudden stop in an intersection.
What case overrules Epler, where the Supreme Court said a sudden stop by a preceding driver approaching or going through a busy intersection should be reasonably expected so as to impose a duty on the drivers which follow them to operate at a safe distance? Where has that been overruled?
That would be the Supreme Court's decision in Burge versus Sharon. And specifically, if you look at footnote number 5 in the Burge case, what the Supreme Court describes there is what's currently expected of a forward driver now that we are explicitly applying comparative negligence law to the rear-end collision cases, which is different from what was going on in Epler. So in Burge, as the Supreme Court describes in footnote
Epler was a 2000 case. I mean, we were a long-time comparative negligence state in 2000.
We were. The issue was squarely presented to the Supreme Court in the Burge case. And in footnote number 5, what the Supreme Court says is that they are not going to decide the disputed issues of fact, but it was for the jury to determine whether or not the forward vehicle made a cautious, slowed down in a cautious and foreseeable manner.
Well, we know that they didn't make a cautious stop because they had no choice under your client's theory. They didn't have a choice. The guy in front of them slams on his brakes, and apparently Mr. Fonger was traveling at a safe distance, and your client either didn't react in time or wasn't following at a safe distance. I'm trying to understand why that isn't the logical conclusion based on your client's theory.
Well, there are going to be two reasons that I want to discuss. First is that the jury is not confined to just the evidence presented by my client and my client's theory. So the case isn't tried just on my client's version of the accident. However, if we were restricting our analysis just to my client's version.
For purposes of the directed verdict, don't we take the evidence in the light most favorable to the non-moving party?
We do, which would be my client, and the motion for directed verdict was raised at the conclusion of all the evidence, in addition to the fact that the plaintiff presented both the evidence of Mr. Fonger and Mr. NALL during the plaintiff's case in chief. But I want to address your specific concern about if the facts were different and that we were only looking at Mr. Fonger's version of the case, which was, Mr. NALL's version of the case, which was that Mr. Fonger abruptly stopped at a green light because of a phantom vehicle in front of him. So if you were only looking at those facts, there's still a burden on the plaintiff to have his own responsibility to be following the forward vehicle in a manner that allows him to make, a cautious and measured stop.
He was able to stop.
And he was
according
able,
to your client's testimony. He
Yes.
didn't hit the car ahead of him.
Not only was Mr. Fonger able to stop, but Mr. NALL was traveling so far back that he was almost able to stop. The accident was a rolling accident. Mr. NALL rolled into Mr. Fonger traveling 6 miles per hour, which actually goes to the whole injury causation issue and why the jury didn't find injury causation. But this was a situation where each of these vehicles was traveling in such a manner that they were able to stop, and in Mr. NALL's
Well,
situation,
obviously
almost
your
stopped.
client didn't, because he actually
Almost stopped.
impacted the car
Exactly.
ahead of him.
Exactly.
Regardless of how fast he was going, he hit.
But that doesn't
Despite
change-
the fact that he saw the car ahead of Mr. Fonger. He saw it stop at a green light. And yet the car between him and that stop car managed to stop without hitting the phantom.
And that was Mr. Fonger's testimony. The jury, however, takes all the evidence into consideration in reaching the verdict. When you look at the Restall case, it was
I
a
think the
similar...
question is, should they have been permitted to?
And that's
based
exactly
on
what
the
I'm, and that's
rear
exactly
end.
what I'm addressing. And this is just like the Restall versus the Nasira case. And if you read the facts in that case, it was interesting there as well. The plaintiff gave less favorable testimony about how she was driving, and the defendant gave more favorable testimony to the plaintiff. But this court reversed it and remanded it back for the jury to consider the comparative negligence of the plaintiff. And the reason that that's done is because the jury is to take into consideration all of the evidence. Burge says that as well in footnote 5. Burge says the jury is going to consider any evidence that's been presented to the
Even
jury.
in a light most favorable, though, sorry, go ahead.
I was going to say, if the issue is whether the presumption applies, why does it matter what the other driver had to say? Don't we have to focus on the evidence in the light most favorable to your client,
Well, the reason
which
that-
would be his story? Because the other driver's story is the light was red. I stopped because the light was red. So he doesn't confess to any negligence at all. So if the jury rolls his version into the event, then they're left with a guy that says, I didn't do anything wrong. I stopped at a red light and the other guy hit me. Versus your client who introduces the phantom vehicle and cannot stop despite the fact that the car ahead of him stopped. Isn't that more like the Douglas Siebert case?
No, because neither the trial court nor this court is permitted to cherry pick the evidence. And that's what plaintiffs asked the court to do. The plaintiff has asked this court to only look at Mr. NALL's testimony, which interjects the phantom vehicle. But that's not the standard on a motion for directed verdict. What the plaintiff's burden on a motion for directed verdict is to demonstrate to the court that there's absolutely no evidence in the record before the jury from which the jury could determine that the plaintiff was at least partially at fault. That's the standard that the trial court was to impose. It's the same exact standard that's before this court. So it's not that at either level
What
of
was that
analysis.
evidence? What is that evidence?
The evidence,
Plaintiff was at fault.
the evidence came from Mr. FONGER. The evidence is that
I stopped at a red light.
there was nobody in front of him. Well, but the jury and the jury specifically submitted a question, and the jury
About
had the
whether
court
he could
ask
tell red from
whether or not he
green.
was colorblind.
But
That's
wasn't
exactly
his
right.
testimony that the light was red?
But the jury's entitled to have believed Mr. NALL that the light was green, and the jury was entitled to ask that question of Mr. FONGER, are you
Didn't
colorblind?
Mr. Nall say he didn't know what color the light was by the time he hit Mr. Fonger?
No, I do not believe, my recollection is that Mr. NALL was consistent throughout his testimony that the light was green at all times,
Even when he hit him?
even when he hit him. Yes,
Not my recollection of the record.
it is. And so, again, this comes back just to the fact that comparative fault must be considered even in rear-end collision cases.
Well,
And whereas,
but just to hit that point, they at least implicitly concede that if we were to remand the case, the jury would be able to consider comparative fault. The question is, does that obviate the fault of your client? Your client might be found to be less than 100% at fault, but isn't that consistent with Burge?
well, that concession in and of itself waives the issue that they're presenting on appeal. The only issue they're presenting on appeal is that the trial court failed to grant a directed verdict finding that defendant, Mr. Nall, was 100% negligent. That's the only motion that they advanced before the trial court. So this court can't reach back into the trial and now view this as if Mr. Fonger had moved for a partial entry of directed verdict. And this is something that's discussed, in a couple of the cases as well, where you see, the courts noting, I think it was the Lirano versus Gonzalez case, I think may have been one of the ones, or the Hernandez versus Gonzalez case, where it was still an open issue as to causation, and the courts talk about that there could have been other motions that would have been advanced at the trial court level that could have partially resolved issues of negligence, but that when those issues and those motions are not advanced, it's not something that can be fixed on appeal. I also want to specifically
Didn't they
mention...
also ask for the jury instruction, though? So
Pardon
when
me?
this, didn't they also request the jury instruction on the presumption of negligence?
There are no jury instructions on presumption of negligence in the state of Florida.
The special jury instruction.
Sorry?
Didn't they request a special jury instruction?
Yes, and there are no permitted jury instructions in the state of Florida on the presumption of negligence other than a directed verdict instruction. So if the plaintiff had been entitled to a directed verdict, the only jury instruction that would have been given would have been to advise the jury that the defendant had been found to at least be partially negligent, which is not the motion that they filed. In this case, they would have been entitled to a jury instruction that the defendant was negligent, responsible for the accident. And that type of directed verdict wouldn't have permitted a consideration of comparative negligence thereafter. So the one motion that they filed, which would have been an absolute directed verdict, they were not entitled to receive because there were conflicts in the evidence, and the issue of comparative negligence needed to be and was properly presented to the jury as a question for its determination.
And a light most favorable as to your client's negligence, or the defendant below, would we have to assume that he saw this tan vehicle at the intersection with enough time to apply his brakes before the sudden stop by FONGER?
I'm sorry, could you repeat the first part of the question? If-
Would we have to assume that he saw this tan vehicle stopped at the intersection? Because I think his testimony is that I saw the tan vehicle, and then all of a sudden, NALL applies his brakes, FONGER applies his brakes, and he's not able to stop in time from his car impacting. FONGERs.
Well, we don't properly assume anything because we don't get into the minds of the jurors and how they decided this case. You know, what we're looking for are whether or not there were any reasonable inferences the jury could have drawn from any of the evidence from which the jury could have determined that Mr. FONGER was partially at fault. And let me jump to the verdict form and the verdict question that the jury answered. No way can it be said in this case that the jury found Mr. NALL, the defendant, to be 100% free of negligence. The jury did not make such a finding, and despite a plaintiff wanting to stand on that position, that's not what the jury did. The jury answered a compound question that asked whether or not defendant was negligent, which was a legal cause of loss, injury, or damage in this case. The jury was asked to answer a compound question which asked both about the issue of negligence and the issue of injury causation. As I've indicated—
Wasn't it argued, though, that he was, in fact, not negligent, that he acted reasonably under the circumstances in closing argument?
It was indeed argued. So there's three possibilities under this question that the jury responded to. The jury either, number one, found that Mr. NALL was partially at fault. The jury number two found that Mr. NALL was 100% at fault. Or the jury number three found that Mr. FONGER was 100% at fault. Either three of those are a possibility under this verdict. And we're not able to step into the minds of the jurors and determine which of the three they found as being the fact. The second part of the question—
Under what theory, though, is FONGER 100% at fault?
I'm not saying—
Under anybody's theory.
No one's—
we got two versions of the accident. The jury isn't able to come up with a fifth or sixth or seventh version. We got two versions. Under which of those versions is FONGER 100% at fault?
Let's say that the jury is entitled to believe that there was no phantom vehicle in front and that Mr. FONGER slammed on the brakes when he's a mere 5 to 10 feet away from a green light for no observable reason, and that makes him 100% at fault.
It seems like that would be against the manifest weight of the evidence. There's absolutely no evidence to support that.
Well, you take the combination of Mr. FONGER's testimony and Mr. NALL's testimony, and although we're not allowed to cherry pick the facts, the jury is permitted to do that. And if the jury accepts that the light was green, and the jury accepts Mr. FONGER's testimony that he made a sudden stop when he realized a mere 5 to 10 feet away from the traffic light that it was red, then the jury would be entitled to render that determination, and if a trial court denied a motion for new trial, it would not be said to be against the court's abuse of discretion. But I want to get back one more time to the verdict form, because the two-issue rule precludes any reversal in this case, because the jury's answer to question number one on the verdict form, it's very possible that the jury found that Mr. NALL was negligent, but they found—
Why doesn't the Granitas v. Tomlin case from the Florida Supreme Court preclude the application of the two-issue rule in this case?
Can you say which case that is again?
I think it's Granitas. It's 858 Southern 2nd, 999. And there the court said that the two-issue rule does not apply where there's two defenses, and specifically it was the absence of negligence and the absence of causal connection between any alleged negligence, which is a situation we have here. We have multiple defenses to one cause of action.
I don't believe that that case has been cited in any of the briefing, but what I have cited are the two-issue rule cases which state the rule, which is that where there are multiple defenses, which there are here, there was a defense both as to the issues of liability and as to the issues of injury causation, that is exactly when the two-issue rule applies. Because unless the plaintiff here comes forward on appeal, arguing that the verdict is against the manifest weight of the evidence on both of the defenses raised by the defendant, then you can't succeed under the two-issue rule. And plaintiff here has filed an appeal where they've only argued that the verdict is against the manifest weight of the evidence as to the ruling on who caused the accident, not who caused the injury. So because plaintiff has neglected to also present a case arguing that the jury's verdict is against the manifest weight of the evidence in terms of injury causation, the two-issue rule applies, and this court's not able to discern from the compound question which was asked of the jury whether or not there was any error in the jury's verdict. As a matter of fact, plaintiff has waived the second defense because plaintiff's not arguing that there would have been any error in the jury's determination that there was no injury causation.
But aren't the two issues defenses?
The two issues are the defenses, yes.
Why doesn't the 2003 case that Judge Sasso, which says the two-issue rule does not apply to a single cause of action defended by two separate defenses? Whether it's cited in the brief or not, that's what the case says.
I am not familiar with the case, and I am confident in terms of the continuing validity of the two-issue rule as discussed in the cases cited, including one as recently as 2013. However, if indeed the two-issue rule has been discussed in a way that would say that it's somehow the appellee's burden to establish both of the defenses, appellee did touch on that in the brief in terms of demonstrating why the evidence would have supported a conclusion that there was no injury causation. Again, we really shouldn't have to get to the manifest weight of the evidence issue or the two-issue rule because the case was properly resolved on the motion for directed verdict. The trial court did properly deny plaintiff's request for a directed verdict that defendant was 100% negligent because there was evidence that the jury could consider and determine that the defendant was not 100% negligent. Even
Thank
if
you.
99% negligent, it wouldn't warrant the entry of a directed verdict. Thank you.
I would like to briefly touch on the verdict form issue.
Let me just ask on the verdict form.
Yes, Your Honor.
The first question was there negligence on the part of NALL, which was a legal cause of loss, injury, or damage to FONGER? So it's a two-part question. Was there negligence? And if the answer to that is yes, was it a legal cause of injury to your client? So was the jury free to conclude that yes, NALL was negligent, but it didn't cause any injury? In which case, I mean, we haven't really talked about the loss, but I mean, isn't that a reasonable conclusion that the jury could have reached? That, yeah, he was negligent, but it didn't do, no harm, no foul, basically.
I certainly think that there was a harm and a foul by
Oh, but my
allowing the
question is
jury
not
to.
what you or I think, but was it a reasonable conclusion for the jury to say, yes, he was negligent, but no, it didn't cause any harm, and answer the question no?
I guess two parts to my response would be, the first was that the question of was there negligence shouldn't have ever been on the table. That prejudices FONGER because it allows the jury to hear a lot of things and decide a lot of things that they shouldn't have decided. It was a question of law that the court should have decided. That certainly colors the jury's consideration of whether there was any causation, or not causation, but, well, yeah, causation, regarding injuries. I think that's sort of what we're going for in this case, is that this entire portion should have been removed, and that's why our verdict form, which was supplied to the court with supplemental authority, not supplemental authority, in an appendix to the reply brief, was the negligence of NALL the legal cause? That would have allowed the jury to answer that question.
They could have inferred that there was not any injury or damage as a result of the negligence.
It would have given them the opportunity had our form been
Regardless
accepted.
of the verdict form used, though. That is an inference the jury could have reached from the evidence presented.
I don't believe so. I believe that there was nothing presented by NALL to suggest that FONGER was in any way at fault for this accident.
Not at fault, but injured as a result of any fault.
Well, I'm not sure. I'm not sure that we have
I would
enough
agree that there was
information.
evidence presented that he delayed seeking medical treatment, that he had pre-existing conditions, and that he was overweight, and that there was a biomechanical expert that suggested that the forces in the issue in this accident would cause the injury, and so the jury could infer that no injury resulted from any alleged negligence.
No, because there were injuries that he complained of that only arose from this accident. It wasn't simply the pre-existing conditions that he had. There were certainly injuries that were novel to this particular accident. And as far as the 6 miles an hour goes, that simply it isn't supported by NALL's own testimony. If these cars were going 6 miles an hour, there's no reason why he shouldn't have been able to stop unless he was right on the bumper of FONGER.
Are you aware of any authority going to the cherry-picking argument that this court is constrained to only accept one version of the testimony or the other, and that the jury would not be reasonable in kind of picking and choosing? You know, there's the truth lies in the middle of the two stories sort of theory.
All I can say is that the inferences that they draw must logically flow from the evidence. Any discussion about whether the light was red or green, according to FONGER, comes from a jury question that they presented as to whether he was colorblind. And he answered that question, no, I'm not colorblind. So that ends it. They're not allowed to go beyond the only evidence, which would have been the question to FONGER about his being colorblind or not. They're not allowed to, I'll strike that. No, I think that the jury is largely constrained to what was presented as evidence. And any inferences or stories that are drawn must be reasonable. Any story that would lead to the result that we have here is not reasonable. That goes to the manifest weight. And again, I just want to point out that the single issue rule doesn't apply here because we objected to their verdict form, which was ultimately accepted by the court. Finally, our JNOV motion, our directed verdict motion, did ask for both that FONGER did not show comparative negligence and also that comparative fault should not have been submitted to the jury. We must look at how the court
You
analyzed
exceeded
that.
your time, so rely on the briefs. Thank you.
Thank you, Your Honor.